This is Stan J. Caterbone, Advanced Media Group, www.amg, globalentertainmentgroup.com. It's now 6:54 a.m. Friday, May 4th, 2018. On May 10th, I have a case going before the U.S. Supreme Court, and I'm going to read some of the parts of the case. The case number is 17-8399, title Stanley J. Caterbone, Petitioner versus National Security Agency et al. It was docketed on April 5th, 2018, and on April 25th, it was distributed for the conference of May 10th, 2018. The respondent in the case, representing the government, is the Solicitor General, Noel J. Francisco. He's with the United States Department of Justice, 950 Pennsylvania Avenue, Washington, D.C. And he is the respondent. He represents all the government entities that I filed against. Now I'll read the list of parties on the case. List of defendants: National Security Agency, NSA, the United States Department of Justice, Lieutenant Detective Clark Behringer, Lancaster City Police Department, the Lancaster County Sheriffs, the Lancaster City Bureau of Police, the former Lancaster City Mayor Richard Gray, the Lancaster County Commissioners, Mr. Jeff Sessions, United States Attorney General, the Pennsylvania State Police, the Federal Bureau of Investigation, the Central Intelligence Agency, CIA, the Department of Defense, the Pentagon, the Defense Intelligence Agency, DIA, and the Defense Advanced Research Project Agency, DARPA, and in the Pentagon. Now the case is from case number 17-1904 from the U.S. Third Circuit Court of Appeals. I'm going to read the most important part. In the petition, you have to cite why you believe that the Supreme Court should take the case. And I'm going to read from my actual petition. Now, if you get online and you look up U.S. Supreme Court docket search, all you have to do is enter Caterbone, and you'll find two cases, my Lambert case and this current case. Reasons for granting the petition. You can actually download this petition. These issues are of national importance, especially since the disclosures of whistleblower Edward Snowden and the existence of warrantless surveillance in the National Security Agency, NSA. The United States Supreme Court is the most appropriate court to rule on this case. It could be said that the district court judges were most interested in pro se petitioner Stan J. Caterbone taking this case to the said court. The United States Supreme Court would have the unique jurisdiction in ensuring the constitutional rights of private citizens are not compromised and justice subverted through information obtained from warrantless surveillance upon which there is no just cause for any allegations or association with terrorism. Whistleblowers are inherently supportive of a system of checks and balances within our government to go beyond our constitutional doctrines regarding the same. Whistleblowers ensure that the rule of law is universally applied to all government officials in all branches of government. The Federal False Claims Act and its provisions protect individuals from abuse of power while providing relief and remedies for those that were wronged and those that had the courage to cite a wrong. It is too easy for present and future administrations to abuse their power and utilize warrantless surveillance as a means of subverting and obstructing justice for those that are engaged in whistleblowing cases that concern national security. Without the proper oversight and judicial review, a whistleblower can be placed on terrorist lists for malicious reasons without the knowledge or just cause. This is in direct conflict with keeping our democracy free of corruption while adhering to the spirit of the Constitution in the manner our founding fathers envisioned. In addressing the subject of U.S.-sponsored mind control, again, the United States Supreme Court is the most appropriate court to rule in this case. Not since the Church Committee hearings revealed the CIA's MKUltra program has there been a national public debate regarding the legalities of U.S.-sponsored mind control and the prospects of resistance. And as important, due to the recent attacks to the United States Embassy in Cuba, the same said weapons, again, the United States Supreme Court has the unique advantage of jurisdiction. The very fact that the above two issues are used to obstruct the right of process of pro se petitioner Stan J. Caterbone since 1987, due to the fact that federal, state, and local authorities were at the very least complicit without the judiciary taking on the responsibility of criminal referral to the proper authorities, begs another critical question regarding the state of affairs of our democracy and the erosion of our basic civil rights at the hands of illegal and corrupt covert activities by the military-industrial complex and the intelligence community at large. The normal checks and balances put into place by our founders, namely the freedom of the press, have been exploited and abused by the same set actors by implementing a campaign of fabricated criminal charges and mental health issues of pro se petitioner Stan J. Caterbone in the most corrupt and criminal way. The abuses and activities that are central to this case have the dire cumulative effect of evolving our democracy far from the spirit and laws of the Constitution of the United States in ways our forefathers never have envisioned. The U.S. Supreme Court has the responsibility to our democracy to insist that the lower courts litigate this case in a manner that preserves our civil liberties and for the first time acts as the system of checks and balances that keeps the abuses of the military-industrial complex and the intelligence community from eroding the United States Constitution to the point that our founding fathers would not recognize. Now, the initial case that is the result of the U.S. Supreme Court case being filed is actually a preliminary injunction for emergency relief, where I asked the federal courts to step in and stop the stalking, the harassing, the computer hacking, the thefts and vandalism to my home and property, and things like that. Again, this case will be heard by all the Supreme Court justices next Thursday, May 10th, 2018. Now I'm going to read to you what a conference is, and this is taken from the U.S. Supreme Court website. To conference. According to U.S. Supreme Court protocol, only the justices are allowed in the conference room at the time. No police, law clerks, secretaries, etc. The Chief Justice calls the session to order, and as a sign of collegial nature of the institution, all the justices shake hands. The first order of business typically is to discuss the week's petitions, deciding which cases to accept or reject. And that will happen next Thursday with my case. Again, this is Stan J. Caterbone, Advanced Media Group, www.amgglobalentertainmentgroup.com, and this video will be on my YouTube channel, and I'll also put it up on Twitter.